first question out of the gates, are there any agreed strikes or set overs before we get going?
No, Your Honor, but I have two motions for attorney fees, which are really probably very short.
Sure, go ahead.
All right. Yes, Your Honor. The first one would be the minor guardianship of Dalen.
All right, and do we have all the parties present?
Donald Esau for David Birch is present.
All right. Do we have Mr. Goodday? And there appears to be, like, on the 5th that there was the court was going to sign an ex parte extension of the emergency minor guardianship. I don't see that that's been entered. Is that in the works?
Yeah, I believe we turned in all of those pleadings to the court. Yeah, I'm not sure where it's at. I did
want to check.
Okay, I did get everybody's signature over, electronic signature, so I can always have it run over to the court again.
Okay. It's really not before me today, but I just wanted to see but given it's been only 2 days, I guess, since that was ordered, it probably hasn't made its way to where I would see it in Odyssey yet. I see your proposed order. Did you send one over for me to actually sign today, Ms. Winkles?
Yes, there was an original sent over, actually at the same time as the emergency order extending. So They might all be together somewhere.
Yeah, I unfortunately don't have that.
Your Honor, did Teresa bring you in a folder of orders?
I have a folder of orders for my presentation docket, and then she brought an order for the Rasmussen case, an order for the Bishop case, and an order for the Gronitz case. That's what I was provided.
Okay, I can look through my orders again just after docket.
And we'll also run them over to the court again. It's no problem.
Okay, I do see the proposed order and the declaration. Let me review that. I wasn't able to review the docket before it started. I'm sorry. And since we are here solely for that motion for attorney's fees, I'm assuming nobody else wants or needs to weigh in.
No objection here.
And just so Your Honor's aware, it was a little more expensive because the child did have me go to CPS with her to speak to CPS. She did not want to go alone and refused to speak to them.
I see the declaration and the itemization of fees, and I've reviewed the order. So I will sign off on that order once presented.
All right. Thank you, Your Honor.
Thank you.
And I have another one, which is the minor guardianship of Haley.
All right. And looks like we're just again here for an order on motion for attorney fees. I see Mr. Esau is on this case as well, and Mr. Anagnostou is present.
Correct, Your Honor.
Anybody have anything else they need to weigh in on other than this motion for attorney's fees?
No objection to your signing it, Your Honor.
And Your Honor, I was only recently appointed, so I haven't had a chance to look at it, but I would take that, my client would have no position with regards to Ms. Winkles being awarded her attorney's fees.
All right, thank you both. I have reviewed the declaration and itemized fees for this case, as well as the proposed order. Again, I don't unfortunately have that order in front of me, but I will sign it once I receive it.
All right, thank you, Your Honor.
Looks like to approve a petition.
Yes, Your Honor. So we have everything ready. I have everything signed and it's on its way to the court, but it's not there yet. So if we could set it over for a week to give enough time for whoever is on the docket next week to receive those documents to sign.
Sure. So the 14th at 10:30?
Yes, Your Honor.
All right. So the Vrotny matter will be over 1 week to September 14th, 2023 at 10:30 a.m.
Thank you.
Thank you. And we're on for it's
a motion for relief for car insurance payments.
All right.
And I'm not sure is counsel.
Mr. Esau, or did he drop off here? Maybe
We
he
can come
thought he
back to
was,
it.
maybe thought he was done. Do you think you can
I'll-
track him down?
Yeah, I'll go ahead and give him a ring and then I'll come back on.
Okay. Let's move to the guardianship of Azra. Any parties that are associated with this case? Let's see. Do we have a Jessa Booth?
I am present, Your Honor.
Thank you. Do we have Alicia Falconer? Or Mark Bishop? Sandra Chilcott? And I see Miss Day present.
Yes, I'm here, Your Honor.
All right. So the last we were in court, looks like was the 10th of August. There was an order extending the immediate minor guardianship. It was set over to today's date. And then the only thing that's been filed since then was the Miss Day's GAL and Statement of Qualifications report. Let's see. I guess I have some concerns. This case is about at its statutory deadline here for being an emergency minor guardianship. So it would either need to be refiled as a minor guardianship, or otherwise this potentially would be could be dismissed. So do you have any information, Ms. Booth?
I have started filling out the paperwork for the long term. I don't have it completed yet, and I have not heard anything back from the prison regarding Mark Bishop's service, and all of my correspondence with them has been unanswered.
So he's incarcerated. That does make it a little bit more difficult. So I can appreciate that.
Out of state as well.
Oh, out of state as well.
Yeah, father's incarcerated in Arizona and not expected out for at least another year, as best I can tell online. I have helped to provide the information on how to reach the prison, but as was indicated, they just are not responding.
And Miss Dyer, I'm assuming, isn't responding either based on what I've seen.
They've been served. Yeah, Miss Dyer's been served, as has Miss Chilcott. They were served, I think we're well past the date now. They were served in July, both of them. So I guess my position or my recommendation and request would be that, they've had an opportunity to respond. They have not, and that the court grant an emergency order that would allow just enough time for the full guardianship to be filed, and then we can kind of start this process all over again, I guess.
Yeah.
So I do have a proposed order on emergency minor guardianship in front of me here.
Mm-hmm.
It is essentially, it's what we already have. It would be an extension of what we already have. Time frame wise, I'm a little concerned. Let me do some math here. The initial petition was filed, it looks like the 23rd of June, and the immediate emergency minor guardianship was entered on the 23rd of June. And as it's 90 days, I think that we can't go beyond. Is that?
My understanding is it can be extended one time past that once the order's been entered and everybody's been served. That gives her time to do that.
Okay. So here's what I'll do. We are getting very close to the time frame. So I'm gonna extend this. But given the dates and times, I'm only gonna extend it to the 28th of September.
Okay.
So I can't give you any legal advice from the bench, but I would I would probably, if you can, seek out some legal advice, or at least I know that there are some how-to videos for these types of things that are available on, there may be some on our local legal aid website. And I know that some of the other county websites have some kind of step-by-step process information. It needs to be transferred over to a regular guardianship case. The emergency minor guardianships can only be extended for so long. So I will extend it. I'll set another review. Just give me 1 second to kind of change this order to, so you'll need to file a minor guardianship petition. And I'm going to set this to expire and for the review on September. I want to double check my dates here. September 28th, 2023. At 10:30 a.m. So that'll be a review, and that'll also be the date that this extension will expire. It appears that all the other, Miss Day, you're continuing on as the guardian ad litem in this case, correct?
I am the court visitor at this point.
Or
So
court visitor?
yeah. And I think that would be appropriate just until we get the minor guardianship filed. I don't have any concerns about the child's placement at this point. But I will be following up to make sure she's in school and all of those things have taken place given the nature of this, and providing support and getting father served.
All right. So I've just kind of hopefully changed this order enough that it'll work to be an extension of an emergency minor guardianship in this cause number. As I stated, the review date, September 28, 2023, 10:30 a.m. And I've signed that order and we'll get it filed this morning.
Okay, thank you,
All
Your
right.
Honor.
Thank
Good
you, Your
luck.
Honor.
Mr. Esau is back.
Perfect. I'm gonna. And
I
that was,
apologize,
no, that's
Guardian-
okay. Was that
Guardianship
Waldo,
of-
correct?
Yes, it
Amy and
was.
Waldo, 2340. And this is a motion for relief as it relates to insurance.
Car insurance, use of the car, and phone bill. Very simple. Dad is currently paying no child support whatsoever. It was determined that Cowlitz County doesn't actually go after child support on these emergency minor guardianship orders. They only start to attach when there's a minor guardianship in place. So Dad has been paying nothing. Guardians have been paying everything. However, Dad had maintained car insurance for the child, who is both in school, getting excellent grades, and also has a job, and was paying his phone. And the car obviously had originally belonged to Dad. After the emergency was put into place, Dad essentially came back and said, I want the car back, canceled his insurance, and also canceled his phone. So what we're asking for is, in lieu of child support at this time, because nothing's transferred, we ask that Dad maintain the status quo, let the child use the car to get to school and do his job, to pay for his car insurance as he had been, and to also continue to pay the phone pending litigation. Once we get a minor order in place, if we do, child support will attach and the guardian can best make up his mind as to what to use those funds on.
Mr. Esau.
I'm caught off guard here, Your Honor. I don't believe I received copies of the citation and motion for today. I know Ms. Winkles is very diligent about all that, and I might have missed it in one of my emails. So I apologize for that. But what Ms. Winkles is saying might be true. And if it is, this might be appropriate. But may we set this over 1 week for me to get a hold of my client and get copies of the paperwork and respond appropriately at that time.
Ms. Winkles.
And I don't have any problem with that. Mr. Esau is out of state, so we do have to use email. It's not always 100%. We also mail, but again, it's not 100%. And I'm sure he would like to argue something that's before him.
Okay. I'll set up Mr. Waldo's matter over 1 week
Mike
to the
Rothman here from the
14th
state.
at 10:30.
Charles Clapperton, I represent Lena.
Angie Villette, interested party, child advocates.
Hi, Rachel Walway, adoption supervisor.
All right. Do we have,
I believe Kimberly Peterson, I believe, is the petitioner, and I think I see her on.
Kimberly?
I'm here, Your
Peterson?
Honor.
All right, and
So is my husband, Donald Peterson.
okay. All right, so looks like there's a lot of things going on in this case. If someone can give me a rundown of where we're at. I know that there's a motion for reconsideration based on a prior ruling, and we're on for I guess approving a full petition at this point. I don't know if that motion to reconsider impacts that. I wasn't able to review that, so I'm going to put you on the spot, Mr. Rothman. Where are we at?
And I'm covering for someone else. No, but that's fair. So I have argument to make, Your Honor, but essentially the short answer is the department is respectfully requesting that the court deny the emergency guardianship. I have looked on Odyssey for both the guardianship as well as the dependency matter, and have not seen if the judge has ruled and issued a decision in the motion for reconsideration at this time. But essentially, is it all right if I sort of jump into the department's position?
Sure.
As the court's aware, Your Honor, an emergency guardianship under RCW 11.130.225 sets forth two elements which must be met in order for the court to grant this emergency guardianship petition. One, an appointment's likely to prevent substantial harm to the minor's health, safety, or welfare. And two, no other person appears to have the authority, ability, and willingness to act to prevent substantial harm to the minor's health, safety, and welfare. In this case, neither element is met. The child is legally free and placed in the custody of the department pursuant to 1334-210. The department's in full compliance with all statutory requirements in the dependency action and is continuing to ensure the child's safety. She's in a court-ordered placement in Washington State, and there's no indication that she's at risk of substantial harm. There's no risk, like I said, of substantial harm present for this child. Neither element is met, and the emergency guardianship is not appropriate. There is quite a bit of sort of background that we could go into if the court is interested, of how we sort of got here. But at this time, and in the dependency matter, at a hearing in front of Judge Scudder, he did allow for the waiver of exclusive jurisdiction for this court to address minor guardianship, but had made no findings regarding the appropriateness of the plan. So like I said, didn't sort of lay any sort of foundation for this court to find that there should be a guardianship. My client, Ms. Walway, is here. She and I can answer any questions, but don't believe that this is appropriate at this time. Like I said, can sort of flesh it out if you'd like.
Is this, I did have a conversation with Judge Scudder just about an interesting kind of set of facts, and I'm thinking, and I see that the petition, this is the maternal aunt and uncle, and they're out of Montana. Was this one where Montana said we're no longer supporting and it has to go back to home state jurisdiction, and then that started this kind of interesting scenario?
That is that is my understanding. Essentially, the ICPC was rescinded due to concerns regarding medical neglect and emotional neglect. So then the department started making arrangements to bring the child back when they learned that the child was placed with the paternal grandmother in Idaho. And so that's sort of where, I mean, the good news is this child has a lot of family member fighting over her and loves her. So that's the sort of the positive news about all this. But yes, I think that sounds like the set of facts you were aware of.
Okay. All right, Mr. Clapperton.
I represent Lena, the child, and my major concern is that, I mean, where she's placed right now is fine. She has a long relationship. She's currently placed with the step parents, and she's had a long relationship with them. And as far as that, I'm not sure what's going to go on as far as the guardianship with Miss Peterson. I have met with my client, and I know that there were ties to Miss Peterson. As a matter of fact, she's the only parent that she's ever known. Much of the, and I guess my concern is that, yes, the state of Montana, rightly or wrongly, did say, take your child back, and the child had to come back. But at that point, it appears that the department has made the decision of, well, let's not investigate it and see if it was in the child's best interest to stay where she's been 95% of her life. Let's just move on to another relative. And I guess that is my primary concern as far as the damage done to my client, who's 5 years old, by just saying, well, you can have another mommy now, and going and moving to another long-term placement without considering the old placement. Because I know that I've met with Lena. She has brothers and sisters in Montana. She's very attached there. And my concern is what's going to happen to a 5-year-old who's in the middle of all this.
And valid concerns. I appreciate that, Mr. Clapperton. Ms. Peterson, I don't know if you'd like to speak or if you want to defer to Mr. Peterson, but I'd be happy to hear from one of the two of you at this point.
Your Honor, there's a lot I want to say. If we didn't care about Lena and love Lena, we wouldn't be fighting as hard as we have been. We've been doing this since 2019. And I just feel that the department claiming that we don't understand trauma and causing more trauma by the allegations that have been made by Montana, they don't understand the trauma that they're causing, not only more trauma to Lena, but trauma to the other children and to Donnie and I as well. We love Lena with all our heart, and we always have. We wouldn't have done this if we didn't care about her.
Okay. Well, this is this frankly is an awful situation, and I sympathize with the entire circumstances. I don't know a whole lot about this. There was a legal discussion about that I had with another judicial officer that it currently is assigned to the dependency docket, and regarding what occurred with Montana and the need for an immediate action in removal and an action in Washington. So I don't really know much beyond that. I don't, at this point, obviously have any reason to believe that Mr. and Mrs. Peterson were not appropriate parents. Not sure. Sounds like there was some Montana indicated, I think Mr. Rothman said medical neglect was one of the reasons why the child was removed from the home at that point, not having any other information. So I'm not making any rulings based on the ability of the Petersons to care for the child. What I do need to determine based on the state of Washington's rules, and frankly, I kind of align a little bit with Mr. Clapperton here and his sentiment. But there's two things that I have to look at. What is the health, safety, and welfare of the child, and if there's no other party to ensure the health, safety, and welfare of that child. So those are kind of a true two-pronged thing. We currently have an active dependency case. We currently have and there's been no indication that a current placement is unsafe, inappropriate, whether it's ideal. Unfortunately, that's at this point not before me to make a determination. Because those two prongs, I guess depending on how you say it, have not been met by this petition, I am going to deny the order for emergency guardianship. My hope would be that and I understand that exclusive jurisdiction was waived in this case for the dependency. My hope would be that the department would continue to consider the Petersons as potential placement down the road, or if adoption is the long-term goal, to consider them. Obviously, I'm not there or involved in that, so I'm not ordering or dictating anything, but I do appreciate that they stepped up, took care of this child for an extended period of time, and have care for this child very much, and do want her back.
Your Honor, I understand your ruling, but I just wanted to inquire if you had had an opportunity to review the report of child advocates that Mr. Clapperton submitted in this case previously. It is an odyssey.
I don't see that. If I don't know if Mr. Clapperton, is there a index or anything you can refer to, or maybe when you filed that?
I'm going on Odyssey myself because I know that Angie's correct, that it is there. Let me bounce down there. If you'll notice on 828, it says copy of CCC response to motion to reconsider for case 19, and then it gives the dependency number. That is, I put a cover sheet for the guardianship on Miss Vallette's response that she filed in the dependency, because I was still going, well, because I know how courts work if it's not filed. And so that is it. And it's 7 pages long.
Okay, and I did not look at that because I thought that was part of the reconsideration. So, and that wasn't what was on today. So I did not. Let me, and I do see, it looks like Ms. Vallette, if I'm skimming through this as quickly as I can here, that you're supporting placement with the Peterson family at this point. And if not, then that they have DCYF cover the cost of in-person visitation on a regular basis. Is that?
Essentially, yes. There's additional facts if you needed them or wanted them. It's a very thorough report of kind of the goings on that have gotten us to this situation that I do feel is important for the court to be aware of.
Okay, can you summarize that for me instead of me pausing for 20 minutes to read your report?
Yes. So Montana did rescind the ICPC. They attempted to rescind it in May for the exact same reasons. What they failed to do is offer any services to remedy any of the concerns that they had. They didn't put any services in place. They made referrals.
Are they required to under Montana law?
As the acting supervision of the child, I believe that they are the ones that have to make the referrals for Montana providers to be able to see the child. The problem in this case was that Washington DCYF had not closed out Lena's medical insurance referral, so she was not eligible for insurance in Montana, which is what the basis is for the medical neglect, that the placement did not get medical insurance for the child for quite some time. They allege that she did not have a well child exam, which is inaccurate. She had one in September of 22 and July of 23. Medical insurance is now figured out. She has medical insurance in Montana now. And now that she's back in Washington, that will need to switch again. There were no court-ordered services for this child to be receiving for mental health or occupational therapy. These were things that the social worker had indicated needed to happen, but couldn't. But again, there's no information of any of the allegations that they're putting forth. There's just no evidence. The child not having glasses, she does have glasses. It's hard to get a 5-year-old to keep the glasses on. She takes them off all the time. Additionally, with the concern for safety and imminent risk of harm of this child, she was in Washington. She's still in Washington. She was in Washington for 15 days, and the court in dependency had given the DCYF the indication that they could drop in unannounced daily if they wanted. And DCYF did exactly 0 visits in that time. Child advocates did 4 to confirm that this child was safe in the home of the Petersons. This is the only family she has ever known. I don't believe that DCYF has done their due diligence to keep this family together. Additionally, while this is not an ICWA case, Lena does have Native heritage in the Citizen Potawatomi Nation. At termination, the tribe supported termination and placement and finalization of adoption with the Petersons. If Lena is not finalized for permanency with the Petersons, she is not eligible for enrollment in her tribe. The only way for that to occur is for adoption by the Petersons, because Kimberly is an enrolled member and that heritage comes down through the father's side, and there are no other members of the family that are eligible or enrolled as members of the tribe. So this child stands to lose a lot. Her parents, the people she considers mom and dad, her sisters and brothers, the people she considers siblings, the people who have raised her for several years. And DCYF has been completely uninterested at this point in having the Petersons remain in Lena's life at all. They have fought this every step of the way with essentially no evidence that anything actually ever happened that caused harm to this child.
Okay, so answer me this, Ms. Follett, and I appreciate that information, and it frankly, it sounds like the Petersons should be the people that are responsible for the child in this case. But if I have to make a factual finding that her health, safety, and welfare are at risk currently, and there's no other people to provide for her, when that isn't true, how is the court supposed to just disregard the initial hurdle that I have to make in order to do really what probably is in the best interest of the child? DCYF, I am frustrated with them on a very regular basis, so I understand where that comes from, but I don't know how I can ignore what legal finding I need to make in order to grant this petition. And I know that you may not be able to answer that, but I guess that's the position I'm in. Mr. Rothman, is the state or the DCYF looking at the Petersons as a viable option moving forward?
Honestly, I don't know the answer to that specifically, but I do believe that those issues are best addressed in the dependency matter. There is a dependency hearing set already for October 23rd for a review and permanency planning hearing. I think motions for change of placement, motions for potential going towards adoption, all of those are on the table and should be discussed in the dependency matter. I understand CCCA's position. Ms. Follett's always very well argued in these matters, but I think the court has figured it out exactly, the two prongs that the court has to find, and neither one of those are met in this instance. So while it is difficult and frustrating, I think the law is very clear in this matter. Ms. Walway, I know you indicated you might want to say something. Is there anything you wanted to add?
I was just going to say that we can't, the ICPC was closed, so there's no way for us to consider placement or support a guardianship because there'll be no oversight if she moves back to Montana. And there's an open dependency. So there's no way to even approve that, consider that. ICPC Montana would have to consider that, agree to monitor the placement. We don't have those things. They closed it.
Your Honor, if I could, anyway, just briefly, because I'm an attorney like Your Honor and I don't do these things, I am in the process of getting an expert who worked for both DCYF to go in and look at it. She's familiar with it. She worked, I think she spent 20 years with DCYF and now is a outside contract, to look at it and see what was going on, because I represent the child's best interests, and because of the competing and conflicting social issues, mental health, psychological, social work issues, I'm looking for direction there. And when I get something, I would be sharing it with the court.
I appreciate that, Mr. Clapperton.
Because it sounds like I understand your position.
I'm extremely frustrated because to me, Ms. Follett, I think, was very eloquent in kind of stating the history of this case. It sounds like a lot of the accusations against the Petersons are baseless, and that I've heard nothing that indicates that when the child returned to Washington, that there were any health concerns, safety concerns, that, you know, there was anything of that nature. This is entirely, it's very frustrating. It's really frustrating for the court when there's a situation where you see an avenue that you want to pursue, but legally there's roadblocks. And that's unfortunately the position the court feels that they're in at this point. I can't make a finding that says that she's at risk in her current placement based on the information that I have. Does that mean I agree with the current placement? Nope. Does that mean that I don't think that that ultimately that the Petersons are the proper placement? No, it does not mean that at all. But unfortunately, in order to make a finding here, there's two hurdles the court has to overcome, and based on the information, I can't overcome them. If there was a caveat that, well, whatever is in the best interest of the child trumps everything, that would be amazing. But unfortunately, that there isn't that in this in the statute for minor guardianships in Washington. So I'm going to unfortunately stick with the decision of denial at this point. There is a dependency case still pending. Ms. Villette, I hope you continue your fervent advocacy for this child and the placement of the Petersons moving forward. And I frankly hope, and Mr. Clapperton, and I hope that the Petersons are afforded some opportunity to continue to be a part of this child's life moving forward. Right. I'll sign that order.
Thank you.
I'll prepare an order and circulate it to the parties and get it to Your Honor.
Okay. I have an order of minor guardianship that I just entered a denial on.
Okay.
No,
Okay.
I see,
Perfect.
Stormo.
Yes, ma'am.
And I guess, is Miss Winkle still involved in this case? Because it shows that she is.
I'm not sure.
Okay.
She was representing the parent, Jenny Oxford, or Jenny Beasy.
Okay. Let me see here. So we entered an order. It looks like an order was entered last year, the 22nd of, excuse me, the 1st of September, 2022. And then we are on for an annual review. And I don't see anything else filed as of this point in time. So what is happening, Ms. Stormo?
We are looking, I have Deanna with me here on the phone. We are looking to see if we can get this a permanent guardianship instead of just one more year. I'm retired military and I can't get her on my benefits unless I have a permanent guardianship, and she's preparing for college. And with that, I can use my VA benefits to get her paid for college. So we've had actually a great year with visiting her mom and their grandparents. We just spent a week in Idaho visiting their grandparents. So it seems to be working really well. Other than that is I just don't want to, I have benefits. I work also. So she's on my medical benefits through West Rock, but we just would like to get it more permanent. I did talk to her mom about adopting her. She never really responded to that. But I just need to make sure she's covered for college. And that's the only way I can do it, is get her on a permanent basis, or a permanent guardianship of some sort. I don't know what it's called.
Okay. And is she going into her senior year or starting her senior year?
She's starting her junior year right now.
Junior year. Okay. So there's a little bit of time before college. I do see that the order appointing minor guardian. So, which is, I guess I'm going to call it it's a full guardianship, that was entered last year, is set to, expire today. I don't have any paperwork that's been filed.
I wasn't sure how to proceed, if I had to file more paperwork or what I needed to do. I just saw my paperwork at a court appearance today for it.
So I'm going to be very honest with you, Ms. Stormo. I, first and foremost, can't give you legal advice from the bench. So I'm not allowed to direct you about the steps to proceed. I will let you know a couple things. You are located here locally?
Yes, yes, ma'am.
On Mondays between noon and 2 on the second floor of the Hall of Justice, we have attorneys that volunteer their time to help folks in these types of situations, to at least, here's the forms you need, here's the steps you take, that kind of information. And we'll review paperwork with you during that time period. Let me see here. Because none of that has been filed yet, and this minor guardianships indicates that, hold on. Do you think that if we set over this over 1 week, Ms. Stormo, you can get some paperwork filed and to the court so we can get this addressed
Definitely.
sooner rather than later?
Definitely.
Okay. So it does appear that Ms. Winkles probably is no longer associated with this case. So, and it does appear that new letters of guardianship would need to be issued, and that those would be terminating pretty imminently. So, I'm going to enter a bench order. And that bench order is basically going to just hopefully be a Band-Aid to get us over 1 week to the 14th at 10:30. And at that point, hopefully you can have some things filed and some proposed orders so we can get this extended another year at the very least. And then you can work on other options if there is a avenue for adoption, or if there's a avenue for a more permanent guardianship that can be done before, excuse me, before Miss Oxford turns 18 and before she gets ready to start applying for college.
Okay.
That makes sense?
Yes, definitely.
Okay, so I'm going to do a bench order. And hopefully that will work. I don't know, given the kind of current situation we're in, if there's anything else that I can enter, but I will do a bench order just extending the current guardianship to next week, the 14th.
Okay.
And that'll be the Thursday at 10:30 a.m.
Okay.
Okay.
All right. Thank you so much.
Thank you. Good luck.
Thanks.